Good afternoon and welcome to McLean Middleton's webinar, It's Legal, Now What? Marijuana in Massachusetts and Impacts on Employers and Independent Schools. My name is Adam Hamel. I'm an attorney in the litigation department here at McLean Middleton, and I'm also the vice chair of the Employment Law Practice Group. I'm here with my colleague, Susan Schorr, who can introduce herself.
Hi, good afternoon, everybody. I am Susan, and the focus of my practice area is primarily K through 12 independent schools, student travel organizations, and nonprofit organizations with a social service, human service focus.
So we're going to go through today a discussion of several issues relating to legalization of marijuana in Massachusetts and the impacts that's had on employers and independent schools. We're going to go through our program, but through the program, if you have any questions, you'll notice that there is a chat function that's available to you. So if you have any questions as we go along, feel free to enter those questions into the chat function. We'll collect the questions as we go, and if we have any time at the end of the presentation, we will we'll answer any questions that we're able to. If we can't get to your questions, feel free to email us, and we'll follow up with you after the presentation is over. So with that, we'll get started with what our agenda is.
Okay, so today we are going to start with catching up on what's been happening with medical marijuana, which has, of course, been legal in Massachusetts for several years now. There have been some developments on the case law front, even though the law itself has not changed. So we're going to go over those with you. We will then dive right in and talk about the brand new law, or the newish law, covering recreational use of marijuana. We'll spend some time talking about what you need to know about drug testing employees, and then I'll be wrapping up with some special considerations for independent schools. And the subject matter lends itself to some punning, so we'll try to minimize those. But as a sidebar, if you want to keep track of those, feel free to do that.
I thought it'd be helpful to start out with kind of a brief history of how marijuana has been dealt with in Massachusetts, and it goes back quite a ways. It's sort of interesting that that Massachusetts was one of the first, if not the first, states to actually have any laws that regulated marijuana. In 1911, Massachusetts was the first state to outlaw marijuana. It took the federal government a couple of decades to get on that bandwagon, and the first federal law that regulated marijuana was enacted in 1930. And then, things kind of stayed pretty status quo for several decades. And in 2008, Massachusetts enacted a law that essentially decriminalized possession of up to 1 ounce of marijuana. It used to be that it was a crime that could be put in prison for that level of possession. But then in 2008, essentially it was something you would get a citation for. Then fast forward to 2012, where Massachusetts voters overwhelmingly voted in favor of authorizing medical marijuana. Took a number of years for the regulations and the approvals to get in place, and the first marijuana dispensary opened in Massachusetts in 2015. And then a year after that, voters in Massachusetts, again, by a pretty overwhelming majority, voted in favor of legalizing marijuana for recreational use as well. And then just last year, at the end of the year, the first retail sales of recreational marijuana began, and that process is ongoing, and more and more recreational marijuana dispensaries and retail operations keep going online. It seems seemingly every day in the news we're seeing more and more of that.
So I'm going to take us through just an overview of the medical marijuana law in Massachusetts, and then Adam will follow up with some interesting developments on the case law front applicable to the workplace. So as Adam just indicated, the law passed in 2012 by a pretty wide margin in Massachusetts, 63% to 37%. Took a little bit of time to get things going the following year. And then you can see we're 6 or 7 years in, and there are quite a few 49 registered marijuana dispensaries around the state. And again, that's just for medical marijuana. We've got close to 60,000 patients who are actively enrolled in the program, and close to 300 healthcare practitioners who are able to administer medical marijuana. So the law for medical marijuana designates like who can be qualified to use it and who can be qualified to administer it. So a qualifying patient or a personal caregiver shall not be subject to arrest or prosecution or civil penalty for the medical use of marijuana, provided he or she possesses no more marijuana than is necessary for the patient's personal medical use, not exceeding the amount necessary for a 60-day supply, and presents his or her registration card to any law enforcement official who questions the patient or caregiver regarding use of marijuana. So what I think is interesting here is the law was passed several years ago. Patients are allowed a 60-day supply, which is a pretty generous amount. I'm sure you've all been hearing about the use of opioids and efforts to curb their use, and proposed legislation along those lines, which limits prescriptions to something like 3 to 7 days worth of opioids. So very kind of different approach to those two different types of medications. Another thing that the medical marijuana outlines or defines is what is a qualifying patient. And this, this can be pretty broad. It's someone who's been diagnosed by a licensed physician as having a, quote, debilitating medical condition. And as you can see, those types of conditions are fairly serious, everything from cancer, Parkinson's, Crohn's disease, those types of things. But the law does build in flexibility if a qualifying patient's physician determines that the condition that a patient has is serious enough and would be appropriately treated by medical marijuana. So again, there is quite a bit of flexibility built into the law in terms of who can actually be deemed a qualifying patient.
One thing that is, very noteworthy in the law, the medical marijuana law, is that employers are not required to make any accommodations for the on-site or on-duty use of medical marijuana by employees. So, there's nothing in this law that would require any employer ever to, allow for employees to, consume marijuana while they're on company premises or on working hours, or to be under the influence of marijuana while they're at work. And we'll talk in a minute about, what about off-duty and off-site use. But then the other thing to note is that the law itself includes some specific provisions to protect users of medical marijuana. The statute says that any person meeting the requirements under this law shall not be penalized under Massachusetts law in any manner or denied any right or privilege for such action. So, basically what that means, again, is sort of reinforcing the notion that, people who use medical marijuana legally, will not be criminally or civilly, penalized for that. People can't be, deprived of any kind of, state benefits as a result of, using medical marijuana. So again, as I mentioned, that one I just want to kind of emphasize that nothing in this law is going to in any way require any employer to, accommodate or allow employees to have medical marijuana in the workplace or be under the influence of marijuana at work. But there's a big but to that, a big important difference. And so that relates to, what about the off-duty use of medical marijuana? And there was a case that came out from the Massachusetts Supreme Judicial Court in 2017, Barbudo versus Advantage Sales and Marketing LLC. It involved a woman who she suffered from Crohn's disease, and with the the approval of her physician, she was treating some of those symptoms with medical marijuana. According to the facts of the case, she didn't use marijuana every day, and she used it infrequently, just sort of to treat her symptoms. She applied for a job, and apparently what Advantage Sales and Marketing does is they're one of those companies that does samples of food products at grocery stores, and so she was applying for a job to be a person who distributes samples at a grocery store. When she applied for the job, she was told that she was going to have to take a pre-employment drug test, and she told the hiring manager, well, that might be a problem because I use medical marijuana for my Crohn's disease. The hiring manager told her, oh, I'm sure that won't be a problem, and so they offered her a position. She went and completed her first day of work, and at the same time went through the pre-employment drug testing. Of course, the drug test came back positive, and then Human Resources called her up and said, well, I'm very sorry to tell you that we're going to have to let you go. Well, here at this company, we follow federal law, and marijuana is illegal under federal law, so we're going to have to let you go. She then, sued the company on a whole bunch of different legal theories, and many of which were not ultimately addressed by the Supreme Judicial Court. But at the end of the day, what the Supreme Judicial Court focused on was it focused on our anti-discrimination statute, Chapter 151B, and that has some similarities to the Federal Americans with Disabilities Act, and it requires an employer to make reasonable accommodations to an employee who's otherwise qualified to allow them to meet the requirements of the job. And so what the court did in the Barbuto case was it acknowledged for the purposes of Massachusetts that under certain circumstances, it may be a reasonable accommodation to a disabled employee for the employer to tolerate or allow that employee to engage in the off-duty, off-site use of medical marijuana to treat a medical condition. One of the things that the employer argued in that case was, well, wait, this is something that is, it's a illegal substance under federal law, and we're concerned that we're going to be violating federal law if we tolerate this. And the Supreme Judicial Court kind of set that argument aside and said, well, as the employer, this employee is not going to be having this substance, in the workplace. She's not going to be using it at work. And so to the extent that there's any potential liability or criminal liability under federal law, it's really only the employee who is potentially at risk and not the employer. And so the court sort of set that argument aside, and really what we're left with here is state of affairs is that if you have an employee who identifies to you as someone who is disabled, and as a result of that disability, they're treating themselves legally with medical marijuana, and they're asking for a reasonable accommodation to perhaps be excused from your drug testing protocols, or just an acknowledgement that that you're going to tolerate them using it outside of the workplace. That may be a reasonable accommodation. And an exception to that could be if you are in an industry where you have people operating heavy equipment or driving cars, or if you're a federal contractor, there may be facts and circumstances that make it so that accommodating an employee's use of medical marijuana might be an unreasonable burden on you, and that you could make the case that you don't need to accommodate it. But again, each case is different and fact specific. Obviously, every employer needs to review those facts and consider it with their employment counsel. But sort of the takeaway here is that a blanket rule that we as an employer are not going to tolerate any use at all of our employees of marijuana outside of the workplace is potentially problematic. And so just another sort of look at this is, the Massachusetts Commission Against Discrimination, the MCAD, that's the administrative agency that deals with all sorts of, any claims of discrimination in employment and housing and other areas in Massachusetts. And so, in the Barbuto case, the court considered what the MCAD's view on this is. And the MCAD's view is really kind of what the court came out with at the end. And it talks about how, the failure of an employer to consider the offsite use of medical marijuana as a accommodation, potentially is a violation of Chapter 151B. And so the courts, as they often do, in the application of the anti-discrimination statute did give quite a bit of deference to the MCAD. So here we've got both the MCAD and the Massachusetts courts coming down in favor of, at least considering whether or not the use of medical marijuana by an employee is a reasonable accommodation. Another interesting wrinkle here is, well, what about workers' comp? And this is interesting that, you have an employee who, let's say they're injured in work or they have some condition that arises out of their work, they're eligible for workers' compensation benefits. And, if part of that, that benefit is that they've got a recommendation from their employer, from their medical provider, that they should be using medical marijuana. Question arises, is that something that the workers' comp carrier can be made to pay for? And recently, an administrative law judge for the Mass Department of Industrial Accidents, and that's the state agency that governs our workers' comp coverage here in Massachusetts. The administrative law judge found that the carrier cannot be forced to pay for medical marijuana. But interestingly, just last week, the New Hampshire Supreme Court ruled exactly in the opposite and said that it was wrong for a workers' comp carrier to deny reimbursement to an employee for their medical marijuana use. And what I thought was very interesting here, and my next question is how would the SJC rule on this issue in Massachusetts? So if this administrative law decision were to get appealed and end up before our state Supreme Court here in Massachusetts, how would they rule? You can never predict, of course, but my suspicion is that the Massachusetts court would come out in the same way that the New Hampshire court did. And the reason for that I feel that way is because a lot of the reasoning that the New Hampshire Supreme Court had in that case was very similar to the kinds of reasoning that the SJC used in the Barbudo case. So, hard to tell if this case ever will come before the SJC, and if it does, how they would rule. But my suspicion is that they would follow what New Hampshire did, and that it's quite likely that medical marijuana in Massachusetts could potentially be covered by workers' comp. The next thing is, and I mentioned before about federal contractors. And so what about federal contractors? And as we keep saying, marijuana is still a Schedule I illegal drug under the Controlled Substances Act. And so, even if you are an employer in a state like Massachusetts that allows medical marijuana use, what do you do if you're a federal contractor, or if you're a federal employee working in one of these states? So what the what the law requires is a federal law called the Drug-Free Workplace Act. And so federal employees and federal contractors are bound by that. And what that law requires is that any company that receives any federal grants, or if it has a federal contract that's worth at least $100,000, the employer is required to have a drug-free workplace policy and a drug-free awareness program. And that there's some consequences here, that a company that violates the Drug-Free Workplace Act, they can see their federal contracts being terminated, or they can be barred from future contracts for up to 5 years. An interesting story that was in the news over the last few days is involved Elon Musk, who we all know from Tesla, but he's also the head of SpaceX, which is is working with the federal government to create rockets that are they just recently docked with the International Space Station. They did that on behalf of the federal government. Probably a few months ago, there was a video that circulated around the internet of Elon Musk smoking marijuana with a comedian, Joe Rogan. And so this video has come to the attention of the federal authorities, and who knows what will happen here, but they're looking into that and investigating what effect that video could have on SpaceX, their government contract, and the ability of Elon Musk to continue to be a federal contractor. So interesting stuff. And with regard to this issue of federal contractors and what do the courts say? I mean, there was an interesting case that came out very recently. It was out of the federal district court in Connecticut that dealt with this issue. One thing to note, sort of importantly, is that because this is a, from the trial court level in the federal court, it doesn't have any, precedential value. It's not binding on other courts, but it is interesting in that it might kind of give us a window into how courts would look on this. And the facts of this case in Connecticut are in many ways similar to what happened in the Barbuto case that I've already discussed, where an employee, someone who worked for a federal contractor, was legally using medical marijuana, and they were told that they had to pass a drug test. They told the employer in advance, well, I'm using medical marijuana. I don't think I'm going to pass this test. They took the test. Of course, they came back positive, and the offer of employment was taken away. The employee then sued, saying that it was, that it was improper for them to, lose this job as a result of their off-duty use of medical marijuana. The employer, made a lot of the same arguments, but even more forcefully, because they were a federal contractor, saying, well, look, we're a federal contractor. We're bound by the Drug-Free Workplace Act, to have this drug-free workplace policy, and we're really kind of, it's beyond our control. What the court, though, what the judge in the Connecticut federal court case said is it sort of, looked a little bit more carefully at what that law says and says, yes, it is true that an employer who is a federal contractor is required to have a drug-free workplace policy and a drug-free workplace, awareness program. However, according to this case, there's nothing in that law that actually requires employers to conduct pre-employment drug testing. And so because that employer chose to do something that was, over and above what the law required, this court, in this case, found that was, unreasonable and went, over and above what the employer was required to do, and said that it was inappropriate in this case for the employer to fire that employee. Interesting to see, what'll happen as, more of these cases come up, or if the case gets appealed to the appeals court, to see, what happens. But again, sort of one look into how one court might deal with this issue. And so lastly, I think that with regard to this issue about, looking at kind of the interplay between, state and federal law on this issue, and what's going to happen here, the question is, are there any legislative fixes that are in the works? And there is, a Massachusetts state representative has recently proposed some legislation that will prevent termination for off-duty use of any marijuana. So what we've talked about is, that there's the Barbuto case, provides some potential protection to employees who are, engaged in the off-duty use of medical marijuana. But as it stands right now, there's nothing in the statute or any case law that provides employees any protection, for their off-duty use of recreational marijuana. So there's some movement in the state legislature to try to, change the law to protect those kind of employees. And that's on a state level. On the federal level, there was an act that was proposed in the last Congress. It was called the Fairness in Federal Drug Testing Under State Laws Act. And what this bill would have done is it would have provided protection for federal employees for their off-duty use of medical marijuana in states where, where it is legal. That bill was not acted upon in the last Congress, and it has not yet been reintroduced in the current Congress. So it'll sort of remain to be seen, what happens there. But it does appear as though there's, sort of more and more, interest and support in Congress at the federal level to have some protections here. And most recently, Senator Cory Booker from New Jersey, who's running for president, has introduced a bill that would legalize marijuana at the federal level. If that were to happen, and if that bill were to become law, then a lot of what we're talking about here might sort of be rendered moot, because then a lot of the sort of tension that we're dealing with here is sort of this tension between we've got state law that allows it, but it's still illegal under federal law. If this movement to finally make marijuana legal under federal law, gets some traction, then we could be having a different conversation. But until that happens, we're still in the position of having to wrestle with these these complicated questions.
So this is Susan again. I wanted to talk about alcohol and drug use under the Americans with Disabilities Act, or the ADA, a federal law which interplays with our own state laws on accommodations and disabilities, but just wanted to provide that context and overview as well. So with respect to alcohol use, someone who has alcohol use disorder is viewed as having a disability and may be entitled to consideration of an accommodation if that person can still perform the essential functions of the job. However, this is similar, not too dissimilar in terms of other types of drug or substance use addiction. That person should not be actively using while they're on the job. So if you as an employer smell alcohol in someone's breath, or Adam will get into, when we talk about drug testing in a few more slides, get into more details about how you might assess whether or not an employee is impaired. That may still give you cause to take some sort of an employment action against someone if they are currently using alcohol. But if someone is in treatment for use of alcohol, for past use of alcohol, that is something that may be considered, or would be likely considered as a disability under the ADA, and therefore trigger the need to have that interactive dialogue where you may discuss accommodations with that employee. So with respect to marijuana, and again, there's this caveat and reminder that as of now, it's still illegal. But in terms of how Massachusetts will view it, I think I would refer you back to the discussion of the Barbudo case. We've got pretty good indication here that our courts in Massachusetts would encourage employers to engage in that interactive process with respect to marijuana use. But again, if any other sort of illegal drugs, if there's legal use of any substance, that is not something that would, that sort of negates anyone asserting that they have a disability or something that should be afforded some protection under the ADA. So I wanted to give a little shout out to Cannabidiol, or CBD, which has also gotten quite a bit of attention as the sort of non-psychoactive sister compound to THC, which, as most people know, is the psychoactive compound of cannabis or marijuana. There are something like 200 or 400 different marijuana or cannabis compounds. So these are probably the two that are the most well known. And again, CBD, it can contain trace amounts of THC, but generally speaking is not considered psychoactive. I should say there's been quite a bit of press about it, but it certainly is something that is not thoroughly vetted by the medical community. There's not been, again, because of the prohibitions under federal law, it's hard for clinicians and scientists to have done a lot of research on it. But certainly anecdotally, it's thought to be very helpful in terms of relieving pain, inflammation, nausea, anxiety, helping with sleep. To that latter use of CBD, I will point out, not outside of Massachusetts, the tricky thing here with CBD is how it may show up in a drug test. There was a woman who was using CBD to help her with sleep, and she worked in a type of environment where there was drug testing, and her use, she came up with a positive drug test, and her explanation to her employer was that the positive test was triggered by her use of CBD. But of course, there was no way for the employer to prove that. And so even though I would say many CBD products probably would not trigger a positive test, you just don't know. It's not regulated and you don't know what you're getting. There is only one pharmaceutically manufactured version of CBD that has been approved by the FDA, and it's a kind of narrow focused drug for treatment of rare forms of epilepsy. So just an overview on CBD, which most commonly comes in the form of an oil, but like marijuana products, also can be available in edibles, gummy bears, jellies, liquid vaping, all those kinds of other versions of it. So we're going to transition away from medical marijuana and talk about the newer law, which in Massachusetts, which is permitting use of recreational use of marijuana. So this law passed by a much more narrow margin than medical marijuana in 2016. It was 53 to 46%-ish. And first retail sales, the Cannabis Control Commission was established, and for those following, the local news over the past couple of years, there were lots of ups and downs and ins and outs in terms of getting retail locations actually established. So it took until November of last year, 2018, for the first retail establishment to open up in Western Massachusetts. And to Adam's point about how rapidly this area is developing, I had worked on these slides about a week ago, and within that week, I had to update this slide to say where it's now available and opening soon. I heard just on the news this morning, there was approval for Lowell, and last week, I think we heard Brookline will be coming online soon. And I think regardless of the substance use challenges of using marijuana, the biggest focus for communities where these establishments are opening up is the traffic patterns. There's a lot of, by that I mean vehicular traffic and not other types of traffic. There was an application, I live in the South End neighborhood in Boston, and there was an application for a retail location not too far from me on Tremont Street, which was recently turned down. So we'll see if Boston proper has a location opening at some point, but for now, the closest ones in the Boston area would be upcoming Brookline and in the Merrimack Valley, Lowell. So just an overview in terms of what the new law permits. If you are over the age of 21, you may possess up to 1 ounce of marijuana outside in the home, and outside the home, and up to 10 ounces in your own home. But there is this caveat in the law that if you've got more than 1 ounce at home, the overage must be in a safely and secure locked location. You can grow up to 6 plants at home, and you are permitted to give but not sell up to 1 ounce of marijuana to another adult, another friend. It is, I would note, still illegal to operate a motor vehicle under the influence of marijuana, and of course there's been much debate in terms of how that's even established. If you're under the influence while operating a motor vehicle, this doesn't easily translate to the blood alcohol level, which tests for drunk driving. So I think that's an area where we'll see probably regulations being fine-tuned and developed. And you wouldn't know this if you work or live anywhere near Downtown Crossing in downtown Boston, which is where my office is, but as I walk home every evening, I feel like I'm walking through a corridor of marijuana smoke, but nonetheless, it is illegal to consume it in public and to smoke it anywhere that tobacco is prohibited.
I thought about the workplace implications or considerations with regard to recreational marijuana. And so this is a little bit more straightforward, I think. Under the recreational marijuana law, that employers are not required to tolerate or accommodate, again, the on-site, on-duty use of marijuana in any form, whether medical or recreational. But however, with regard to, the statute itself, the recreational marijuana statute does not in and of itself provide employees with any, job-related protection or put any requirements on employers for protecting employment of people in connection with their use of recreational marijuana. So under the law, employers are still able to have, they're still able to maintain, drug-free workplace policies and testing practices as they always have. However, there's some risk here. So we sort of proceed with caution because, again, as we talked about, these sort of blanket policies that people have about, drug-free workplaces or drug testing, as we talked about with regard to medical marijuana, or even if someone's not specifically using it at the direction of a doctor, if they're self-medicating, now that recreational marijuana is allowed, maybe I don't bother going to my doctor or getting a medical marijuana card, but I still, am choosing personally to treat my migraines with marijuana. That then, potentially, even though the person is not using it specifically under the medical marijuana statute, there may be some exposure to employers for disability discrimination there. Also, there's also the risk of, discrimination other than disability discrimination, depending upon how policies are, worded and how they're enforced. For instance, if, a drug testing policy, just so happens that it's only enforced against employees who are part of a racial minority or some other protected category, that's potentially a big problem for employers. So, that in terms of, the workplace policies and practices that employers have, you always want to make sure that they're being applied in a uniform and non-discriminatory way. The other thing too is that there's been some discussion about whether or not a workplace policy that could be seen as impacting people's off-duty behavior is an invasion of their privacy. People have in Massachusetts the right to privacy, and so an employee could say, well, what does it matter to you, employer, if I'm consuming marijuana recreationally at home and I'm never impaired at work? Why should that have any why should that affect you in any way? And so this is this sort of invasion of privacy theory has not been tested yet, but it certainly is out there and is at risk. So in terms of considering what sort of workplace policies you have and what sort of implications or risks they might have, employers need to be aware of that and give some careful consideration to how you're drafting and implementing your policies, and not just necessarily automatically rely on the old policies that you've always had. In terms of, we talked a little bit about, sort of the federal, the interplay between federal and state law here and how that works with federal contractors and things like that. But I want to talk for a minute about sort of considerations of federal enforcement. As we've mentioned kind of over and over again, that, marijuana is still classified as an illegal substance under federal law. And so the question becomes, if I'm someone who is using either medical or recreational marijuana, what sort of risk do I have for liability here? And there's been some activity in the federal level, and I don't want to go so far as to say that it's like a wink and a nod that there's sort of, but there are indications that that the federal government is not really that interested in prosecuting individuals for sort of small-time use of medical and recreational marijuana. So there was an amendment that passed in 2014 that specifically prohibited the Justice Department from spending funds to interfere with the implementation of state medical marijuana laws. And there's certainly no similar federal protection relating to recreational use, but we should be mindful of kind of who's in charge at the Department of Justice now. The first Attorney General that was appointed by President Trump, Jeff Sessions, he was really seen as being someone who was very anti-drug and anti-marijuana, and so the signals that he was giving was that there was going to be some pretty harsh enforcement against these issues at the state level. The new Attorney General, Barr, he's sort of sending out signals that maybe he's going to be taking a different approach. And on that same line, the U.S. Attorney here in Massachusetts, a gentleman by the name of Andrew Lelling, he issued a statement last summer where he said specifically that I'm not going to immunize residents of the Commonwealth from federal enforcement of marijuana, but he indicated basically I've got bigger problems to deal with. He specifically referenced the opioid crisis that really is taking up a lot of resources in his office. And also he indicated that the kinds of things that the U.S. Attorney's Office here in Massachusetts will be looking into is things like overproduction, people who are, growing more marijuana that they're entitled to, or, people who are targeting sales of marijuana to minors, or also, to the extent that organized crime or gangs get involved in this. But, with regard to, your regular sort of, run-of-the-mill individual who's just, using small amounts of marijuana either for medical or for recreational purposes, the indication is that this is not an enforcement priority of the federal government. So we're going to shift now and talk a little bit about employer drug testing, okay? And, and this is something that we could have an entire session on this. So we're really just kind of buzz through and talk about the high points of drug testing. But one thing I wanted to, point about is sort of the trend here is that what we're seeing is that fewer and fewer employers are continuing to do drug testing, and there's a couple of reasons for that. Number one is there is a reluctance on the part of employers to penalize their employees for legal off-hours use of marijuana. And then there's also, the fact about legislation and court decisions, but also the other important reality here is that we're currently in a economic environment where, unemployment is very, very low. There's a lot of competition among employers to try to find, qualified employees to meet their needs. And so what the unfortunate reality is that a lot of employers who kind of had these sort of blanket policies, or pre-employment drug testing protocols, they were finding it very, very hard to find applicants who they were able to hire. So we're seeing fewer and fewer employers engaging in sort of blanket pre-employment drug testing policies. But with regard to what you could or should do with regard to your own drug and alcohol policy, the number one recommendation is you need to have a policy that this is something that you're not going to want to deal with after the fact on an ad hoc basis. If you've got an employee who you think is under the influence of something, that is not the time to stop and say, well, what are we going to do about this? You really do need to be proactive, have a well thought out drug and alcohol policy in place, and you also need to make sure that you're enforcing it consistently and uniformly. And so some kind of high-level points about, what a drug testing or drug and alcohol policy should include is it should include sort of clear guidance as to sort of what your testing protocols are. It should specify that, participation in drug testing is a condition of employment. Should explain, what types of drug testing that the employer is going to do, and explain what the consequences of not participating in testing, if requested, are. And then lastly, I think that, what your policy can and should include is a statement that, again, that marijuana usage or possession in the workplace is not protected at all under any circumstances by any law. So that can be part of your drug policy. So in terms of, drug testing itself, a lot of people, used to see this more in the past and not so much now, people who had policies for random drug testing. And this is an area where I think, extreme caution is called for if, you're going to want to use random drug testing. And part of the reason for this is that there's so much opportunity for potential overreach or discrimination, or just sort of mistakes to happen with random drug testing. Mostly it's because if these policies are not really carefully implemented and consistently enforced, what is called random drug testing doesn't end up really being random. And so the cases find that that only certain employees or certain types of employees are targeted. So there has been some looking at this practice done by the Mass Supreme Judicial Court. And so what the court looks at sort of on a case-by-case basis, the facts of the case as to whether or not random drug testing is going to be appropriate. And really, at the end of the day, it's going to be, whether or not it's sort of, job related and safety related. So, if you've got employees who are, driving cars or for long hauls, under those circumstances, perhaps maybe it might be appropriate to have a random drug testing policy. But if you're talking about, just, sort of run-of-the-mill office workers, more likely than not, that's probably not going to pass muster. So again, random drug testing is something, proceed with caution, get advice of counsel before implementing that kind of policy. And then the next issue is, post-accident and reasonable suspicion testing. So again, as always, make sure you have a policy in place and you're enforcing it appropriately. But, with regard to, reasonable suspicion testing, if you have an employee in your workplace, and this applies both to drug use as well as alcohol use, but, you have an employee in the workplace who you think is under the influence of something, you look to your policy and say, well, how are we going to deal with this? The complaints about this could, come from, various sources. Coworkers could come to a manager and say, oh, I think that, so-and-so smells like they're, I smell alcohol or I smell marijuana on someone. So the sources of the complaints could come from anywhere, and managers need to, be attuned to that. The first point of contact really should be, human resources, or, if you don't have a dedicated human resources person, whoever the company officer is, whether it's the CFO or the CEO or president who's in charge of that. And the other thing too is that when you're dealing with these sort of reasonable suspicion circumstances, you want to make sure that the facts are, they're objective, factual observations, not rumors or suspicions and things like that. And things really need to make sure you're documenting exactly what is it that was seen, and what was it that was observed, and who was it observed by. Because, if it comes to pass, that an issue is raised later on, you'll want to have that documentation to make sure that the policy was implemented appropriately. Here's a list of some things, what to look for in terms of, considering whether or not there's reason to believe that an employee is under the influence. And, you can sort of see what some of those things are. In terms of, observing and documenting those indicators, again, what we're looking for here is, a pattern or combination of conducts, plus some sort of, indicators of impairment. What you're really seeing is there a reasonable belief that this person who we're suspecting is under the influence? It might be helpful to, have a checklist in place as part of your policy that, that managers can follow, because, when the situation arises, it'd probably be a, kind of a pretty emergent situation. There might be some sort of stress and confusion. So, to the extent that you can, arm your frontline managers with checklists and policies, that's helpful. In terms of, determining whether or not, reasonable suspicion exists, again, more than one observer, don't want to just rely on one person observing. So, if an employee or a manager thinks that someone is under the influence, bring another person into the room and kind of get them to get a sense of what the person is going on. And then, arrange to meet with the employee in a private area. And what that meeting will entail, that it should involve, someone from management, an employee, and then a witness. You want to make sure that there's not just the management representative and the employee in the room. Explain to the employee what has been observed and documented, and then explain to the employee that you want to rule out a possibility of a violation of the company's drug policy. And in order to do that, in accordance with our company's policy, we're sending you out to be tested for drugs and alcohol. And then, as part of your policy, you would have that employee at the time, sign a consent to be tested for drugs, and explain to the employee, consistent with your policy, that if they choose not to consent to the drug test, then they'll be subject to discipline in accordance with the policy. The next thing that would happen then is that the employee would then be transported to the drug testing facility, and as part of your policy and protocol, you would already have a testing facility designated that would be who would do your testing. You want to arrange for transportation for the employee. Obviously, if you've got someone who you think is under the influence, you're not going to allow that employee to transport themselves. It's not advisable to have someone from management be responsible to transport the person. Likewise, you don't want to allow the employee to, have a friend or a family member transport them to the drug testing facility because of the opportunity for some, tampering to happen, in between the workplace and the drug testing facility. So, the best practice is to have the person transported by cab. Human Resources would call the drug testing facility in advance, say, we're on the way. And then, what to do while you're waiting for the results. The employee, stays at home off the job until the results come back. If the results are negative, reinstate the employee and, consider whether or not the employee gets paid for the time that they were out due the drug testing. If the test comes back positive, consider what you're going to do. Do you refer the person to your employee assistance program? Do you give them some coaching and some guidance and some, an opportunity to reform and, and give them another chance? Regardless, again, your policy is going to guide. So, and I think that kind of in closing with regard to this issue of drug testing and policies and things like that, again, I just want to reemphasize, you got to have a policy, you've got to enforce it, objectively and uniformly and consistently. And the other thing too to keep in mind, I think, is that while this whole legalization of marijuana in Massachusetts kind of seems like a brave new world and we're trying to navigate our way through it, in many ways conceptually it's very similar to the way that employers have been dealing with alcohol in the workplace and alcohol policies for years and years and years. And I sort of predict that 5 to 10 years from now, this will not appear to be as big of an issue to employers as it is. And so the tools that you already have, the practices that you already have with regard to the way you deal with alcohol use in your workplace can be, I think, sort of helpful guides to you in the way that you're dealing with marijuana in the workplace. So now I'm going to turn over to Susan to talk about kind of particularly with regard to school issues.
Yes, in our last few minutes together, I just want to highlight some special issues applicable to independent schools. As Adam just said, in some ways, not much has changed for schools in particular with respect to marijuana, the legalization. It is still illegal to possess or consume any form of marijuana and have accessories, paraphernalia, etc., in any pre-K through 12 school campus, school grounds, and school buses. Transfer to or possession of marijuana by anyone under the age of 21 is prohibited. So again, that even for students doing a PG year, I think most of them would be well below the age of 21. So that would really cover the K through 12 world. But I do want to highlight, as Adam spent some time talking with you about the Barbudo case, even for students, if there is a student who is a qualified individual for use of medical marijuana, and minors can be qualified to use medical marijuana under our law, and they are using it off campus, there may be that need, thanks to the Barbudo case, to engage in that interactive process. So just something to be aware of even for students. I think in terms of your policies on the school, to consider how to address if you do come across a student who happens to be to possess these small personal use amounts of marijuana. I recommend talking through perhaps with your local council in terms of developing a policy, what you're going to do in those instances. It may be a good idea in advance of something like that happening to reach out to your local police precinct and to talk to them about what they advise in terms of if you find yourself in this situation. I certainly recommend, if you do come across a student who is possessing or using marijuana, that you don't, remove the materials. You can take possession of them and let away from the student, certainly, but I would give a call to the police. Again, you may, in advance of this happening, ideally work out with your local law enforcement how they want you to handle this. We have heard in some instances, in many instances, frankly, the police quite honestly have better things to do than worry about a teenager who happens to be caught with a joint. So police often don't want to, may signal to you that they don't want to be involved in this type of discipline matter or even in taking possession of the drugs. So if that is the case, I would just make sure you don't get too creative in terms of how you dispose of this, the drugs, but that you document carefully that you have done so, date and time, how they were disposed of. So if this ever comes back to be an issue of inquiry, you'll have good documentation on that. I just wanted to highlight this issue of parental rights and use of marijuana and how that might affect a child welfare proceeding. The new law on legalization specifically carves this out and signals that if a parent happens to be using marijuana at home, that in and of itself can't be a basis for substantiating a report of what would probably be considered neglect as opposed to child abuse. I have yet to come across a school who has asked me about this. I did come across in the last year or so a school that had, in Massachusetts, that had a student concerned that their parent was out of it due to overconsumption of Benadryl. So the school actually, in an abundance of caution, called that report in to the Department of Children and Families, to DCF. I don't believe DCF pursued the matter, but that probably the, whether it's Benadryl or alcohol or now marijuana, that can certainly be something of concern if a parent is so under the influence that they're not able to really be paying attention to their children at home. But that in and of itself, again, the law specifically says should not be the basis for forming a child welfare substantiated report. And then I just wanted to, kind of call your attention. Adam's talked a lot about other types of employers and being careful what your policies say with respect to drug use and alcohol use. And when we come across handbook policies, they're often referred to, in different terminology, right? Illegal drugs, illicit drugs, controlled drugs. So I would just use this as an opportunity to take a fresh look at what your handbooks might say. Of course, your employee handbooks, but as importantly, your student and parent handbooks, and make sure your language is consistent. Because this is now legal in Massachusetts, although it's not legal for minors, those under 21, you might consider mentioning or calling out specifically that despite the new legal landscape for marijuana in Massachusetts, use and possession is still illegal on school campuses. And then also, maybe worth noting, especially for schools that have not in urban campuses, but are in more rural parts of the state or have campuses with a water feature on their campus, like a pond. So there's kayaking and canoeing and not even motorized vehicles. Use of marijuana remains illegal under those circumstances as well. So I think that rounds out, we've just hit the hour, and we have gotten a few questions, which we will, if you hang on for a couple of minutes, we'll try to address those.
Yeah. If you need to log off, that's fine. And thank you very much for joining us today. We hope you found this to be worthwhile and of some interest. But I did want to just, we got a couple of questions that I think that I could, spend just a minute answering. And one of the questions was a question of whether or not the presentation slides will be available after the presentation. And yeah, if you're interested in getting a copy of our presentation, feel free to shoot us an email. We'd be glad to make that available to you. So if you'd be interested in that. One of the other questions that came in was whether or not stress or anxiety is considered as a reason why someone could be using marijuana. And as we talked about before, in terms of what the qualifying patient and conditions are, is that it lists in the statute in a number of sort of specific and pretty serious medical conditions, but there is that sort of catch-all that's in the definition of other conditions as determined in writing by a qualified patient's physician. So if someone is able to get a physician to say that their condition, whether it's anxiety, PTSD, or migraine headaches or something like that, if they can get a physician to certify that that is a serious medical condition that justifies using medical marijuana, they could get a marijuana card. The other point that I would make with regard to that, again, is that now that marijuana is legal for recreational use, there's nothing that prevents someone from legally obtaining and using marijuana to essentially sort of self-medicate. And so, the issues that we talked about in terms of potential accommodations for someone's disability, I do think that we need to be open to considering that for employees, even if they're not specifically prescribed marijuana by their employer. And then the other question that we got was relating to post-accident drug testing. And so, for instance, what the questioner asks is that, if an employee has a medical marijuana card using marijuana off duty, but then the next day at work they have an accident on the road and then they get a post-accident test, the test would come back positive, and how do you determine whether or not the employee was using off-duty or not? And this is a real challenge because, it's a challenge with the science. I mean, there is ways that, law enforcement and drug testing people can determine, with regard to alcohol, if someone is currently under the influence of alcohol, blood alcohol tests and breathalyzer tests, et cetera. But with regard to marijuana, you can't, there's no reliable scientific test to determine if someone is under the influence, at the moment. And so really this gets down to the issue of, what your policy says and whether or not it's a reasonable accommodation. And it's all going to be very fact determinative. If you are in an industry, where, you have, very sort of safety sensitive jobs, people operating motor vehicles and equipment, things like that. That's part of the analysis that I was talking about under the Barbuto case, whether or not, a reasonable accommodation can be made for an employee. So, again, in the Barbuto case, the person was, handing out samples of food at a supermarket. And so, that was obviously not a safety sensitive issue. But, if someone is operating a motor vehicle on behalf of their employer, maybe the analysis is that, it is not a reasonable accommodation to allow that person to be excused from your drug testing protocol. So, when you have these issues, again, facts are going to be important. So, you want to be careful about what your policy is and consult with your attorney before you, as you're drafting your policies and enforcing them.
We've got a couple more questions we'll try to get to if you want to hang in there for a moment.
Again, this next question was a related question, with regard to reasonable suspicion drug testing. And again, someone tests positive, but they say, that they weren't, that they smoked marijuana, the night before. And again, that piece with regard to the reasonable suspicion, that's why it's really important to make sure that your observations of that person, are, objective, well documented and documented by more than one person, because again, with regard to reasonable suspicion testing, what we're talking about is there's a reasonable suspicion that that person is currently at that moment under the influence of alcohol or drugs. And so what you're going to want to do is make sure that, your documentation shows what are the facts and the factors that, led you to believe that there was a reasonable suspicion that the person was under the influence. So that I think would be really important.
One more question.
So again, this last question, again, if a safety-sensitive employee has a prescription for medical marijuana, do we still have the right to terminate if they fail a random drug test that is based on the safety of their role? So again, I think that goes back to what I was talking about before about, random drug testing and sort of the peril of having that kind of policy in the first place. So I think that again, with regard to anyone who's got a random drug testing policy, I would strongly encourage you to review that policy and those practices with your counsel, because of sort of all the risks that are entailed there. But again, with regard to someone failing a test and having a prescription for medical marijuana, really the question will be, again, whether or not, you know, that person is a qualified disabled employee, and whether or not, you know, being excused from your drug testing protocols is a reasonable accommodation under all the circumstances for that person. So again, it's unfortunate that I can't give a real sort of concrete answer, but these really are very, very fact-specific inquiries. So I think that that's all the questions we have.
So thank you so much for all of your good attention today, and please be in touch with us. Feel free to reach out to myself or Adam if you have any follow-up questions. Thank you so much for your time.